Hey out there, legal warriors. In this video, I'm going to cover what happens if you become out of compliance with something you're supposed to do for the court. Even if you don't have something you're supposed to do yet, and let's hope you don't, you're going to want to know this. So if you run into a problem, you know what to do and what not to do. So if you're interested in the side of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 25 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. I'm just going to jump right into it. I'm talking about a situation here in a criminal case. And there's a couple different options. You might be required to do something pre-trial before there's a result in your case, and you might be required to do something post-result in your case, like after the entry of a stipulated order of continuance, or some type of diversionary program, or maybe a probationary period. But let's hope we've avoided conviction if you've got an attorney out there and you're hopefully not on just straight probation after conviction, but it counts for that too. So I'm actually going to start with the pre-trial phase. If you're supposed to do something pre-trial and you become out of compliance, what do? Well, first let's give an example. A pre-trial situation might be, hey, you're not supposed to drink. And to make sure you don't drink, we might do a couple different things. The court, that is. The court might order you to put like an ignition interlock in your car, or the court might order you to use some type of blow device, right? Or the court might order you to wear a scram device. And that's what I call the Lindsay Lohan bracelet. Sorry, Lindsay, on your leg. So in this situation, this hypothetical, you might guess, there's some type of consumption of alcohol. And if alcohol is consumed when you're supposed to not be consuming alcohol, these devices may pick it up. So what do? Well, the first thing you're going to want to do is talk to your attorney immediately about what it is that is showing up that's a problem. In other words, if you blow to start your car and you get locked out because there's an alcohol reading, well, your attorney needs to know that so they can predict what it is you need to do. If it's a false lockout, we might have you go do a random urine test or something at an agency to show that you weren't drinking, right? Let's get a UA. If it's something that really happened bad, well, we're going to try to make sure you do certain things, right? Depending on how bad it was, we might get you a higher level of treatment so we can address it later, or we might have you not drive for a while and so it comes back, we let that get out of your system and so we have more arguments later. If it's a scram device and there's been alcohol consumed and you get notified by someone of that, then we're going to want you to do certain other things. We're going to want you to quickly keep track of where you were at the time of the supposed violation, what was around the atmospheric area, stuff like that, because scram doesn't actually register what you drink. It registers alcohol in the atmosphere of all things. And the rate of dissipation of that alcohol supposedly tells the AI overlords at this point whether or not that is alcohol being evaporated from your body or it's just perfume in the air. So in those situations, we want you to contact your attorney with details about what's going on, and your attorney will likely be able to figure out some mitigation strategies based upon what's going on in your particular court. In some courts, if I got that phone call, I'd say, look, they don't check that anyway. We don't care. Another court, I'm not going to name the county, and they're going to have the hounds out for you immediately, and they're going to drag you away, and it's going to be a total nightmare. And so you need to talk to your attorney about that. But let's talk about post-resolution. And this one's really important because, believe it or not, the problems post-resolution are bigger than the problems pre-resolution, because sometimes if you disobey a post-resolution requirement, you might end up with a conviction instead of a dismissal, like in a stipulated order of continuance. So in this situation, let's say you're supposed to be doing some classes. Let's say you're supposed to be doing educational classes, maybe anger management, maybe DVMRT, maybe just counseling. And for some reason, you get out of compliance. And what does that mean? Out of compliance means you just probably stop going, right? You decide not to go, you forget about going, stuff like that. Now, you might get contacted by that treatment provider, the psychologist, the anger management provider, whoever, and try to let you know you're out of compliance. And sometimes people just give up. Well, I'm out of compliance. There's nothing I can do. And really, that's not true. If it's post-resolution, usually you can get back in compliance. If you've watched our videos about review hearings, typically all is forgiven if we're back in the good line, right, by the time the judge starts to talk to us about what we've messed up. So if you've missed some classes, don't give up. You're going to want to start those classes again right away. And if for some reason the treatment provider doesn't want you in the group anymore, you need to talk to your attorney, because sometimes we can pull some strings and do an appropriate amount of begging and stuff like that to get you a second chance. But what you don't want to do is just give up. And you also don't want to do things like just forget about it, right? We don't want to forget about it, because your attorney hopefully is going to help you, right, if you become out of compliance. But we can only reach out to you so many times, right? We can call you, we can text you, we can email you. And if you just drop out and you ignore it, well, eventually those chickens are going to come home to roost, like they would say, where there's going to be a negative problem. Additionally, let's go back to that alcohol situation. Maybe you're ordered to be in alcohol treatment, and for some reason you drink and you get a positive UA, and now a non-compliant report gets set out. In those situations, you may not know that there's a non-compliant report. Usually your attorney, if they're like our firm, we're going to see the report and then let you know. Almost in all situations, then we need for you in that situation to work with your treatment provider to get an increased level of treatment. So you can say, court, it's been addressed. The treatment provider is having this person do a little more treatment in response to the relapse. Remember, relapse is part of recovery. And if we have that done, remember, by the time we get to the court, if we're back in line, we have a better chance for them to say, bad boy, bad girl, but I'm going to give you another chance, because all we care about is you get the help you need and the outcome that you need. And so many times people can get out of compliance, and there are ways to fix it, but we've got to put in the effort to fix it to make up for whatever happened that got us out of line to begin with. So I hope you found that helpful. If so, please like and please subscribe. The point is, it's not hopeless or helpless. We need to do things to make it right. And if you have a legal problem in Washington State, a criminal matter, feel free to reach out to our firm. If we get on board, listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.